Okay, we're recording. So welcome back everyone to the Civics Project, and particularly to our session on voting rights. I'm Beth Ribet, the host of the Civics Project and the founder of its host, or co-founder of its host organization, Repair, and I'm glad to be with you to talk about this important subject. And I'd like to begin with a land acknowledgement. Repair acknowledges the Tongva, the Gabrielina Tongva peoples, as the traditional land caretakers of Tovangar, the Los Angeles Basin and South Channel Islands. And we are grateful to have the opportunity to work for the Troxatome, the indigenous peoples in this place. We pay our respects to Hanukvatam, the ancestors, Hihiram, the elders, and Eohinkem, our relatives and relations, past, present, and emerging. And as noted, today's remarks will focus on the subject of voting rights. And in order to get into the subject, I want to begin with some discussion of the U.S. Constitution. In Article 1, Section 4, the Constitution states that the times, places, and manner of holding elections for senators and representatives should be prescribed in each state by the legislature thereof, but Congress may at any time by law make or alter such regulations. So what the Constitution sets up is a scenario in which, unless Congress passes specific legislation, the default rules for electing representatives to the U.S. Congress revert to the states. So it's up to the states unless Congress intervenes. And then Article 2 of the Constitution deals with the election of the president, and it's been altered over time. Originally, the top two candidates for the office of president, the winner would become president, and the first runner-up would become vice president. So you had basically a scenario in which the president and vice president could have been opponents, and that created a number of challenges. So later, the 12th Amendment to the Constitution created separate elections for the president and the vice president of the United States. So the vice president wasn't someone who was also competing for the role of president. They were running distinctly for vice president, and then eventually we evolved the system of having the president and vice president run on a ticket together for each party. And in addition, the 20th Amendment, which we've discussed in a prior session, also altered the constitutional rules after the Franklin Delano Roosevelt era by creating term limits for the presidency, which had not existed beforehand. A couple other sections of the Constitution bear specifically on voting rights. One, of course, is the 15th Amendment, which was passed in 1870, approximately 5 years after the end of the Civil War, and which indicated that the rights of citizens of the United States to vote could not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude, so being previously enslaved. And the 15th Amendment also gave Congress the right to enforce that first provision through legislation. Later, the 19th Amendment in 1919 indicated that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation. So the 19th Amendment, which came along in the beginning of the 20th century, provided the right to vote essentially to women. So 1870 provided voting rights to Black people primarily, and also opened the door for other populations of color to access voting rights potentially. And 1919 did away with the ban on voting for women. Now, I want to talk a little bit about women and the right to vote. And I want to go back to the 19th century a little bit to understand the history of struggle. Actually, you know what? I'll go back a little bit earlier. I want to talk about the Revolutionary War era and just acknowledge briefly that the initial conception of voting rights was limited to white people, to adult men, and to people who were landowning. And then states could also create additional restrictions in many cases. So as most of us know pretty well, our Constitution was never in its founding intended to guarantee universal voting rights for all people or even all citizens. It was meant to preserve the right to vote for the relatively elite. So the process of trying to make voting rights comparatively more universal has been a continuing process of struggle since, again, the late 1700s or the late 18th century. So the 19th century was particularly riddled with struggle over the question of whether women might eventually secure voting rights. And the suffrage movement continued to gain strength during and after the Civil War era. And in 1872, suffragists, and many of you know the term suffragist refers to someone who's advocating for voting rights for women, made a decision to work on registering to vote en masse in their localities and attempting to vote. And the question of whether they would be allowed to in the place where they lived, of course, was this basically question of civil disobedience. For instance, the famous suffragist Susan B. Anthony did manage to register to vote and voted in a local election in New York, but then was arrested for it. So in 1875, the question of women's voting rights came before the Supreme Court through the person of Virginia Minor, who was a woman living in Missouri, who sued the Registrar of Voters. His name is Reese Happersett, for denying her efforts to register to vote and to participate in voting. So Minor versus Happersett in 1875 made it all the way to the U.S. Supreme Court. And the court had a few questions before it in the Minor case. One question that was posed in the Minor case was, does the 14th Amendment, which had been passed immediately after the Civil War in order to provide equal protection of the laws, so the 14th Amendment, which prohibited denials of equal protection of the laws to U.S. citizens, ensure the right to vote. So the question before the court was, does the 14th Amendment guarantee women the right to vote? And in order to answer that question, they had to answer two underlying questions. So one, they had to figure out, as a woman, a U.S. citizen, right? Because if she's not defined as a citizen, if she's property or chattel, then the 14th Amendment isn't going to protect her because she's not a citizen. And if she is a citizen, do all citizens have the right to vote based on citizenship? And we can remember that this was not a foregone conclusion, given that in prior eras in U.S. legal history, it had initially been understood that voting rights were guaranteed only to a very, very limited subset of persons in the United States. So the court had to figure out, are women citizens? And if they are citizens, does that mean they have voting rights based on citizenship? The court came to the conclusion that women can be citizens or are citizens, unless they're nationals from somewhere else. But that citizenship does not guarantee the right to vote. And this was in 1875. In other words, voting is not a universal right of citizenship. Nor, therefore, the court held that the 14th Amendment did not guarantee voting rights for women. I next want to look a little bit, now obviously this wasn't the last word. Let me just finish this thought. It took another over 2 decades, but eventually the effort to amend the Constitution in order to ensure voting rights across the nation was successful, as noted, through the 19th Amendment, which was passed in 1919. And some states started giving women voting rights earlier than 1919, but it was not a universal right throughout the United States until that time. Even then, not all women necessarily enjoyed voting rights. There were still some ways in which, based on other identities, they might experience barriers to voting, particularly women of color and women with disabilities, women who are incarcerated or in mental institutions, and in many instances, women who were poor or illiterate. So there are a wide range of historical barriers to voting before and during what we call the Jim Crow era. So the Civil War ended and emancipation occurred in 1865. And one of the central questions in defining the United States as a nation was what its relationship to racial equity, citizenship, and civic participation would become. And that remained an area, as many of you know, of deep struggle. So the term Jim Crow eventually emerged to describe a range of historical barriers to civic participation and social participation that were directed at Black people. I want to just give folks a little bit of a history of the origin of the term Jim Crow, where that term comes from. It was invented in the earlier 19th century, specifically the 1830s, by a white actor known as Thomas Dartmouth Rice, who went by the nickname Daddy, so Thomas Dartmouth Daddy Rice. He created a theater character. He was basically a traveling minstrel, and so as part of his minstrel show, he created a character called Jim Crow. He performed Jim Crow in blackface, and the character of Jim Crow represented Black people as mentally disabled or impaired, as clumsy and kind of laughable, and as enslaved. And he continued to perform Jim Crow over a period of time in the early 19th century. But after the character ceased to be performed, the name was remembered and really revived, particularly in the early 20th and mid-20th century, to describe this wide range of laws, including but not limited to voting laws, which were intended to ensure the continuance of Black subordination, to ensure that Black people retained the social status of Jim Crow, the character. So the civil rights era in the United States essentially involved a dismantling of a number of Jim Crow laws. And I want to talk about what those laws included, that this is not exhaustive. I'll be specific, of course, to those that bore on voting. So one was what was called poll taxes. So some of you may know this term, and it refers to a payment that people need to be able to pay in order to allow people to vote. So there were a lot of laws in the United States which continued to reduce or just failed to protect economic opportunities for Black people and for other populations of color, as well as for women, and for some poor whites. And so having a poll tax became a significant barrier to being able to vote. Most people of color simply could not afford to do it in at least some localities and time periods. An additional voting barrier in the Jim Crow era was, and sometimes before, were literacy tests. So tests for literacy meant a person had to prove that they could read, and literacy at that time was often a privilege of the middle and upper classes. So populations who were disproportionately poor then were denied the right to vote because they could not read. Land ownership requirements still persisted in some instances and time periods, though for the most part those were phasing out and gone by the 20th century. And overt violence was also a barrier to voting, so using kind of racial terror, including through networks and organizations like the Ku Klux Klan, also were a way in which people were kept for voting. And again, we want to understand that this was often under the color of law or with the sanction of law in a municipality, particularly if the same people who made up local law enforcement, police and sheriffs, were also Klansmen and were participating in cross burnings and lynchings and in other activities intended to send a message to Black communities that any sort of attempts to assert citizenship rights would meet with violent results. One last area I want to mention in the Jim Crow era was what was called grandfather clauses, and it relates to the concept of being grandfathered in, if you've ever heard that colloquialism. So grandfather clauses existed in some municipalities or states, and they basically indicated that you could only vote if your grandfather did. So this, as you can imagine, was often an effective way of keeping people from voting if their ancestors had been prevented from doing so. So poll taxes, literacy tests, land ownership requirements, grandfather clauses, and overt violence or simply refusing to allow people to vote included some of the historical barriers to voting before and during the Jim Crow era. So the civil rights era resulted in the passage of the Voting Rights Act of 1965, also sometimes known as the VRA. So the VRA exercised Congress's prerogative in Article 1, Section 4, right? So Congress had the right of oversight. Voting rules and laws could be left up to the states, but the federal government could step in and alter state regulations at its discretion. And what the Voting Rights Act did was create a set of federal protections to override state-level discriminatory voting practices, particularly to roll back or overturn Jim Crow laws. The Voting Rights Act identified states with a history of racial discrimination based on 1960s era data in voting and required them to secure federal approval, which is also known as pre-clearance, before making changes to their voting laws and procedures. So not only did the Voting Rights Act override laws that were resulting in racial discrimination and sometimes class discrimination in voting, but it also said before you pass any new state-level voting laws, which could be new ways to engage in race discrimination, you need federal permission. So you have to get the federal government's okay before you can implement changes to your state-level regulation. So the federal government cleaned house on existing laws and said, we're going to monitor. You can't pass new voting legislation unless we approve it. It didn't do this for every state. It only intervened in this way for those states which had a documented statistical pattern of race discrimination in voting at the time that the Voting Rights Act of 1965 was passed. So voter suppression, voter discrimination continued after the Voting Rights Act was passed, but the law provided new bases for legal challenges to entrenched discriminatory practices. And one of the consequences of it was that the voter participation of Black, of Indigenous, of Latinx, and of other populations of color improved significantly in the 1970s and 80s and beyond. So I'm going to take us up now to the 21st century and a landmark Supreme Court decision just about 7 to 8 years ago in Shelby County versus Holder. So Shelby County versus Holder was decided pretty soon after Barack Obama's second term began, and it challenged portions of the Voting Rights Act on constitutional grounds. It claimed that by using 40-year-old data about race discrimination, is it 40-year-old? Yeah, more like 50-year-old at that point, that it violated state sovereignty and unfairly burdened some states. So the basic idea is that was the 1960s, these problems aren't present anymore, and the VRA is just now just intruding on states' rights and state sovereignty and doing it in a discriminatory way because it's only targeting some states and not others. The underlying question, both practical and ideological, in the Shelby County versus Holder case in 2013 was, were those U.S. states which continued to be monitored and regulated by the Voting Rights Act still at risk of replicating 1960s era patterns of race discrimination in electoral legislation and practices? In other words, could these states with a history of racist voter suppression be allowed to function independently in their electoral processes without federal oversight? And the court found that the Supreme Court in 2013 found that the Voting Rights Act was placing an undue burden on those states required to seek federal preclearance. So those states which, as of the 1960s, needed federal permission to change their voting laws. In 2013, the Supreme Court found, yeah, those states shouldn't have to do that anymore. and the Voting Rights Act in 2013 was therefore violating principles of federalism. And for anyone who needs a reminder, federalism refers to the balancing of power between the federal government and regional or state governments. The court also found that the preclearance provisions violated equal sovereignty among states. So because only some states were restricted by the Voting Rights Act, it was basically saying these states have less sovereignty than others, and found that that was unconstitutional as well. Now, the 2013 Shelby County versus Holder decision went into effect very rapidly, and so it was starting to affect voting practices as early as the midterm elections in 2014, and is now widely considered to have affected substantially the presidential election in 2016, when Donald Trump defeated Hillary Clinton in the electoral vote, but not the popular vote. I want to be careful to not say that the only reason that Donald Trump won was because of the Shelby County versus Holder decision. I don't think that's true. I think there's a complex set of factors, including, for instance, problems in polling, which sort of mispredicted what was happening, increasing voter participation from white nationalists, probably more resistance than the Democratic Party was imagining to electing a woman. Some allege that James Comey's critical findings released about Hillary Clinton also affected the outcome of the election, and there's significant allegations that grassroots level voter suppression, which still would be prohibited under laws but nevertheless occurred, also affected the outcome. But many legal analysts and scholars are of the opinion that the Shelby County versus Holder decision did have at least a significant, if not a primary effect on the 2016 November presidential election. Data analysis since the 2013 Shelby decision indicated that fairly rapidly, once the Voting Rights Act pre-clearance requirements were lifted, a number of those states that had been regulated by the Voting Rights Act implemented a host of new election laws that likely would not have been approved before the 2013 Supreme Court decision, and that had the consequence of disproportionately purging voters of color from the voting rolls. So as noted, some analysts feel that the Shelby County versus Holder decision was instrumental in the Electoral College win of Donald Trump in 2016. There's a lot more that we can say about this important subject, but I want to leave some time for discussion, and I also want to share a book recommendation. My book recommendation for today is by Carol Anderson, and the book title is One Person, No Vote: How Voter Suppression is Destroying Our Democracy. So for those joining us live in Zoom, I will go ahead and put the book reference in the chat. And again, just want to read that out once more. Carol Anderson's book, One Person, No Vote: How Voter Suppression is Destroying Our Democracy. I'm also happy to share our weekly trivia questions. I'm going to do that now, visually for our Zoom audience and audio for both the Zoom and podcast audience. So first questions. When did Indigenous persons in the United States gain the right to vote? Answer choices are A, 1870, B, 1924, C, 1965, and D, 1975. So the answer to this question is a little bit debatable, but generally the most accurate answer is considered to be C, 1965. Now, 1870 marked the passage of the 15th Amendment, which indicated that it was unconstitutional to deny a person the right to vote based on race. However, in its interpretation, this was not applied to Native peoples, who are often not interpreted to be U.S. citizens. In 1924, the Snyder Act was passed at the federal level, which allowed Native peoples to be the right to vote, but did not guarantee that states could not legislate over that right. So it basically said Native people can be given the right to vote by their states, but still left a lot of states' discretion to deny voting rights to Indigenous people. So some would answer that Indigenous people gained the right to vote in 1924 with the passage of Snyder Act, but Indigenous people were still unable to vote in many states and municipalities up until at least the passage of the Voting Rights Act in 1965, which overturned a number of race-based barriers to voting. And I'll also, one of the last option that you were provided with was 1975, in which the Voting Rights Act was amended and in some key respects strengthened. But I would say the most correct answer to this question, when did Native people gain the right to vote, was 1965. Second question, can voting rights be denied on the basis of disability? The answer choices are A, nope, never. People with disabilities always have a right to vote. B, yes, but only on the basis of mental incapacity. C, on the basis of mental incapacity or impaired judgment. Or D, yes, on multiple bases. So the correct answer on this one is that voting rights can still today be denied on the basis of disability, but only on the basis of mental incapacity. So for instance, you could not deny someone the right to vote legally because they are a wheelchair user, because they are blind or visually impaired, because they are hard of hearing or deaf. But you could deny someone the right to vote on the basis of mental incapacity. And the interpretation of that regulation is still contested and shows up in both state and federal courts. For instance, people who have various kinds of developmental disabilities, including Down syndrome and autism, among others, sometimes are placed into what are known as conservatorships or guardianships. They mean the same thing, but the term varies by state. So for instance, New Jersey has guardianships, California has conservatorships, but it means the same arrangement. For an adult with a disability, being placed in a conservatorship or in a guardianship means that a court has awarded someone else the ability to make decisions for you. And some states will decide that as soon as someone is in a conservatorship or guardianship, they're also incapable of voting. Now, keep in mind that loved ones or family members might initiate a conservatorship or guardianship process over loved ones who, for instance, are able to work and live in their own home, but are not able to pay their own bills. So you can imagine that this causes some constant contestation, that if a person is in a guardianship or a conservatorship, does this mean that they can't vote at all? Another instance, if a person is clinically depressed and in a mental institution, does this mean that they should be considered incapable of voting, right? So there's still a lot of gray area, even in the category of mental incapacity, about determining when a person is or is not capable of exercising the judgment needed to vote. Third question, what is a caging list? Answer choice A. A caging list is sending registered mail to addresses of registered voters of another party as a precursor to a voter purge. The basic idea is you'd send registered mail out, and then in any instance where the letter comes back where nobody signed for it or where it wasn't received, then you try to purge that person from the voting rolls. The second option, a caging list requires voters associated with one party to provide additional proof of identity. Answer choice C. A caging list targets particular populations for misleading or dishonest ballot information. And answer choice D, none of the above. And the right answer on this one is the first one. A caging list is the practice of sending registered mail. One party can initiate this, so the Republican or Democratic Party could send registered mail to addresses of registered voters in the other party or in a neighborhood that primarily votes for the other party. And then for whichever letters did not come back, or did whichever letters were returned, whichever mail was returned, could then use that to assert to the county in question that those voters should be purged from the rolls. Now you can imagine that there are lots of reasons why someone might not receive a registered letter. For instance, they're never home to accept it. And with working people, this is common, and that if you only target some neighborhoods, this could result in a lot of voters being purged from the rolls. So a caging list is generally understood as a highly unreliable way to determine who is living in a county, but that is often used to purge voters, sometimes used, I should say, to purge voters from the rolls. And one question you might ask is, well, is that legal? Is it allowed under, for instance, the Voting Rights Act? And court decisions about caging lists have been inconsistent. So the short answer is, in some states, it is still legal to do this, and in others, it's not. And the Supreme Court has allowed it. So I'm going to place some additional learning options for our Zoom attendees into the chat, and I want to thank everybody who's been listening in. We'll have some more discussion after the recording is ended. I want to invite everybody to join us next weekend for our session on Medicare and Medicaid, and on April 18th for our session on the intent doctrine, which is a section, which is an area of legal doctrine which indicates that in order to establish that discrimination is occurring, you need to prove the intention of the alleged discriminating party. As you can imagine, the intent doctrine can make civil rights enforcement very difficult. And we're going to be joined by a special guest from the Equal Justice Society, so I hope many of you will come to hear her. And then on April 25th, for our session on campaign finance, and finally on April 28th for our monthly movie screening. This month we'll be screening The Great White Hoax, which focuses on Donald Trump's use of racial rhetoric. So I hope to see many of you again, and hope many of you will continue to listen in, and thank you so much for supporting the Civics Project.